Good afternoon, everyone. I'm Advocate Khyati Dhuparr, and today I will be talking about the Competition Act. So, this is a video which is on introduction of the Competition Act 2002, and we will be talking about the antitrust or the competition laws in India. So, what is competition law, or what is the Competition Act talk about? Competition law actually is one stream of corporate law. It's actually an economic concept. It talks about having a free market in an economy, right? So that there is good competition, so that it's beneficial for the consumer in the market. The Competition Act 2002 replaced the MRTP Act, which was existed at that point in time, and expanded the scope of the MRTP Act. So this not only covered, your abuse of dominant position cases, but also covered your anti-competitive activities. So let's talk about what are the features of the Competition Act. So under the Competition Act, there is a sectoral regulator called the Competition Commission of India. The Competition Commission of India is empowered to inquire into anti-competitive agreements, for example, cartels or bid rigging, and they can also inquire into abuse of dominant position, including predatory pricing. They regulate combinations, that is your mergers and acquisitions, and they also are empowered to undertake competition advocacy, that is to advise on policy issues. So now let's talk about what kind of agreements are looked into under the scope of the Competition Act. So, under the Competition Act, basically an agreement is not only a written agreement, can also be an arrangement or an understanding or even an action in concert. It could be it could be in writing or oral, it could just be a wink and a nod. It could be, it's not necessarily enforceable. It could be an agreement to do something illegal as well. For example, an action in concert or indulging in a cartel like situation. So cartels are illegal or are anti-competitive under the Competition Act, but they are an understanding or an action in concert which is prohibited under the act, right? So under the Competition Act, let's talk about Section 3, that is the anti-competitive activities. So basically, there are two kind of anti-competitive activities. One are one is horizontal agreements, which is under Section 3, subsection 3, which includes cartel or bid rigging. Uh, to simplify what a cartel is or what bid rigging is, cartel is when there are two players in the market who are at the same level. Let's say there are two manufacturers and they decide to indulge in an agreement where they fix their prices so that the price in the market is stagnant. Okay. So that there is, there's no other competition in the market who's selling the product at a lower price. For example, let's take an example of, let's say there are three manufacturers of a pen in the market, and they fix the price that a pen will be sold at 100 rupees, which is currently being sold at 10. Right. So they increase the price, they indulge into a cartel like situation where they agree that we will fix the price to 100 and nobody will sell it below 100 rupees. And that kind of situation forces the consumer to buy it at a higher price, which, had the cartel not been existent, they could have purchased it for a lower price. But since all the manufacturers increase their price, the consumer is forced to buy at a higher price. This is the kind of situation which is called a cartel. Normally, cartels take place when we talk about public procurement or their government tenders. That's when a cartel-like situation is mostly been seen. When it comes to bid rigging is, again, talking about public procurement or talking about where government tenders or any tender has been released. What players do, they decide to rig the bid. That is, they decide to fix the price that rig, we'll quote a minimum of X price while bidding for the bid. And they sometimes, when you look at a bid rigging situation, you see normally it's the same people who are bidding for the same tender. So they decide amongst themselves that this year, all of us will quote a minimum of 100 rupees, but one guy may quote 99 so that he can win the bid. And next year, player number two will quote a lesser price. And after that, player number three and four and so on, so that everybody gets a chance in the market to quote, win the tender or win that bid. This is a kind of an agreement which is prohibited, or an anti-competitive agreement. It is a horizontal agreement which is anti-competitive. Uh, Basically, all these horizontal agreements, they take place between two players who are at the same level in the market. So it could be two sellers, or it could be two distributors, two or more distributors, or it could just be manufacturers. However, vertical agreements are different. Vertical agreements are between two players who are at different level of a market or a different level of production chain. For example, an agreement between a manufacturer and a distributor, or an agreement between a distributor and the final seller or the shopkeeper. So these vertical agreements are anti-competitive as per section 3 subsection 4 of the Competition Act. So these under the vertical agreements, we look at various forms of vertical agreements, which are like your tie-in arrangements, or there's an exclusive distribution agreement, or an exclusive supply agreement. Exclusive supplier or distribution agreement would be where the manufacturer decides that I will exclusively just sell to one distributor and nobody else. Or the distributor decides that I will only supply to one shopkeeper and nobody else. Or there is a tie-in arrangement where two products which are tied together, where you have to purchase one in order to purchase the second one. That means you are forced, for example, two products which have no relation to each other. For example, if you have to purchase a pen, I will ask you, if I put a condition that I'll only sell you the pen if you decide to buy, let's say, a bottle of water. Two products which are very different and have no relationship to each other. So that is a kind of a tie-in arrangement. Or so there have been a number of cases where it's seen that these vertical agreements are also prohibited. Um, it's prohibited under section 3 subsection 4 of the Competition Act. Now, talking about what are the factors when we look into deciding whether these agreements are anti-competitive. Now, under section 19, subsection 3 of the Competition Act, we look at the factors which make the agreement or an arrangement anti-competitive. These are where there has been um, an agreement to limit or control the production of a product or a supply of a product, where there has been a refusal to deal, where there has been an agreement on the basis of market. For example, two players decide that I'll just sell it in South India and you sell in North India, or divide the product amongst themselves, or where an arrangement results in bid rigging or collusive bidding, or there has been an exclusive supply agreements. So these are some of the vertical agreements. I'm sorry. So factors under 19.3 for determination of your anti-competitive agreements, basically to see that these agreements are likely to cause an appreciable adverse effect on competition in the market. So the factors that you look into are that these agreements are creating barriers of entry in the market, or are driving out the existing competitors out of the market, or is foreclosing the market, or is hampering the development or the production of the market, or whether these agreements are helping or restricting the improvement in production or distribution, or whether there has been an accrual of benefits to the consumer. So basically, you look into these factors to determine whether these agreements are anti-competitive or not. So basically, you have to look into the efficiencies. In case your agreement, even though maybe anti-competitive per se, if it is able to provide you a better, let's say, a better efficiency in the market, or is providing a consumer some sort of benefit in the market, or is increasing the innovation in the market, then such agreements are not penalized under Section 3 of the Competition Act. So they're not anti-competitive per se, right? However, if you see that these agreements are not providing any kind of benefit to the consumer, but creating barriers to the market, or driving out the competitors in the market, basically causing disturbance in the market, then these agreements will be looked into as anti-competitive. Right? Now, talking about Section 4 of the market, Section 4 of the Competition Act, which is abuse of dominant position. So, dominant position is a position in the market, which is a position of strength enjoyed by any enterprise, where they can, work, operate independently of any competitive forces in the market. And basically, being dominant in the market is not bad. So you may be a dominant player. Let's say, we talk somebody like Google. In search engine market, they're a dominant player. Or we talk about Intel in the microprocessor market, they are a dominant player. So being dominant is not bad per se. Your If you are in a dominant position and you are abusing that position, for example, you are causing difficulties for players to survive in the market, or you are creating entry barriers for them, or you indulge in activities like predatory pricing, then that abuse makes you in contravention of the provisions of the Competition Act. So then you're in violation. Your abuse, let's say you're indulging in predatory pricing. So your predatory pricing would be basically where, let's say I am a dominant player who's into manufacturing of cell phones, and I am a dominant player who has, let's say, 50-60% of the market. And I decide to sell my mobile phones at, 100 rupees cost instead of thousands of rupees, which causes all the other players, the smaller players in the market who are selling that similar kind of, or selling a mobile phone at a higher price, that affects their market and forces them to, eradicate from the market. Then this is a kind of situation where I have abused my dominant position. For example, there was a case between the NSE and the MCX, where MCX claimed that NSE had indulged in predatory pricing. And this case was upheld by the Competition Commission, and when it went for an appeal, again the Compat decided that yes, this was a case of a predatory pricing, where NSE, the stock exchange, had decided to not charge any fee for their software, the currency derivative market, but the MCX, which was charging a fee from the people, they were losing out on business. And since MCX was comparatively smaller as in comparison to NSE, MCX was forced out of market of the currency derivative market. And this was a case of predatory pricing, where it was seen that yes, because your NSE was providing those services free of cost, was not charging for the software, was not charging for the services in the currency derivative market, this was a case of predatory pricing. So this was an abuse, or under the Competition Act. So this was an abuse of their dominant position. Now, when we talk about dominant position, there is a very important concept of relevant market. So relevant market is basically what is that relevant product or a geographic market which we are considering into. How do we determine that somebody is in a dominant position? To determine that, we first have to define what a relevant market is. So in each of the cases, the relevant market keeps changing. Basically, there are two kinds of relevant market. Like I told you earlier, there's one product market and the other one is a relevant geographic market. So when we talk about relevant product market, we talk about products which are substitutable or interchangeable with the other product, or goods or services basically, which are substitutable or interchangeable by reason of their characteristics or usage or prices. A product which can be easily substituted. Let's say your iPhone can easily be substituted by Samsung. That means your relevant product market would be market for mobile phones, right? Because your Samsung, your Oppo, your Xiaomi, Apple, they're all interchangeable. Um, Whereas a product which cannot be substituted, for example, your Apple iPhone cannot be substituted for a desktop, because nobody, if the price, let's say, for if a price of your mobile phone increases by 5 to 10%, then nobody will switch to a desktop. The purpose, the price, the usage, the characteristics of a desktop or a laptop is very different from a mobile phone. So for this is how a relevant market is defined, right? Now coming to a relevant geographic market. Relevant geographic market means the market where these goods and services are provided in a homogeneous manner or can be distinguished from other areas. Um, the jurisdiction of the Competition Commission is limited till the geographical boundary of India, which is why your relevant geographic market can maximum be expanded to the country of India. However, when determining what relevant geographic market is, we have to look into whether the competition for or whether the conditions for supply or demand are interchangeable or homogeneous. For example, let's talk about Ola and Uber. So Ola, and if you're talking about Ola and Uber, then the market for Delhi NCR in case of Ola and Uber would be the relevant geographic market, because Ola and Uber provide services in Delhi NCR. However, let's say Ola provides services in Punjab, but Uber does not, right? In that case, we cannot say that the relevant geographic market would be market for Punjab or Delhi NCR Punjab or all of India, because those services are not available in that particular jurisdiction or not, and those conditions for supply and demand are not interchangeable. Sometimes, when we're talking about an industry which is geographically relevant, for example, we are talking about cement industry. In case of cement industry, your relevant geographic market uh, will be defined as per where that particular industry is placed, because something like cement will not be interchangeable throughout the country, because there are costs, logistic costs, which increases. So if a cement factory, let's say, is in a state of Rajasthan, then they are able to provide services in and around Rajasthan. They cannot be providing services in Tamil Nadu or Andhra, because that adds to the logistic issues. So this is one example of relevant geographic, of determining relevant geographic market. So, like I told you, when we are determining the abuse of dominant position, first we need to look into what the relevant market is. Now, how do we determine what is the abuse of dominant position or abuse of dominance? So, we understand that the abuse of dominance is when somebody or the dominant entity is imposing an unfair or a discriminatory condition in terms of price or purchase or sales of goods or services, or they are limiting the production of goods and services, or technical development, or are indulging in practices which result in denial of market access, or are imposing conditions which are not relevant to the subject of the contract, which are disadvantages to the other party, or where they're using their dominant position in one relevant market to enter another relevant market. I'll give you an example of that. For example, let's say Pepsi is dominant. Excuse me. I'm sorry. I'm so sorry about it. Let's say Pepsi is dominant in the market for black soft drinks. Okay, tomorrow Pepsi decides to enter into the market of, let's say, your um, some alcoholic beverage. Now, if Pepsi puts a condition that we'll only sell you a bottle of Pepsi Cola if you purchase my alcoholic product, then basically they are using their dominant position in the market for market for soft drinks into the market of alcoholic drinks. right? So these are some of the reasons or some of the examples of how abusive dominant position takes place. There have been a number of cases when we talk about abusive dominant position and anti-competitive activities. There have been, when we talk about Section 3, I, uh, I'll give you the example of the cement cartel. So this was a case where it was seen that the cement companies, when they were bidding, they decided to fix their prices, right? And because they were fixing their prices, they were resulting in a cartel-like situation. There was an understanding between them that we will quote minimum X price. So this was one example of the cartel-like situation under Section 3, which was found abusive under the Competition Act. The another case was United Phosphorus, where again, when applying for government tenders, the parties had indulged into a cartel-like situation, right? And basically, when they were finding contravention, they were trying to find out the evidences. In a cartel-like situation or in Section 3, there is a very little scope for you to find a written agreement or a legal binding agreement. Sometimes it's just a wink and a nod. So in United Phosphorus, it was seen uh, that, they started considering, basically the commission has the power to consider circumstantial evidences when trying to find out whether there's been a contravention under Section 3, the anti-competitive activities, anti-competitive agreements. So in the United Phosphorus case, it was seen that when the parties were entering the building to enter their bid, to submit their bids, it was just one player in the market who had filled the register and signed on behalf of his competitors in that, register of attendance, that entry register. And this circumstantial evidence was looked into, and it was seen that yes, it seems like that there was something going on between the parties, because why would one competitor, walk into the building and, fill the names of three other players that they have an arrangement, that they have a competition with? And it seemed like that there was probably some sort of an arrangement between them, and that's how this circumstantial evidence was considered, and they were found to be in contravention. Now, when we talk about abuse of dominant position, there was a very landmark case of Shamsher Kataria versus Honda Cars and 13 others. So this was one case where there were 14 major car manufacturers, your Honda, Maruti, Toyota, you name it. Like, there were 14 car manufacturers who were held in contravention because they were using their dominant position in the market of being the major auto manufacturers to force the consumer to buy the spare parts from their authorized dealers. So you all know, as car owners, that there was a situation where you could only buy authorized spare parts from the authorized dealers. You could not find them in the free market. So if I wanted to replace, let's say, an engine in my car, or needed to replace a part in my engine in my car, I had to take it to the manufacturer, to that particular brand's manufacturer's authorized dealer, and that's where I could purchase the spare parts from. And there was always a condition that if you go outside outside the authorized dealers network and get your car fixed outside, your warranty would be terminated. So this was seen as an abuse of dominant position, because if those spare parts can be made available in the market, or let's say are already available in the market, then why would my warranty be void? That means you're trying to protect your authorized dealers market, so that they can, so that, all the money comes into that one single giant network. So this was one case where contravention was seen, and these 14 car manufacturers were penalized to rupees 2,500 crores by the CCI. And this case was actually upheld by the appellate tribunal, the Compat, and now the matter is pending in the Supreme Court. Now, coming back to anti-competitive agreements. So like I told you, that there are horizontal and vertical agreements, but there are certain horizontal and vertical agreements which are exempted from the scope of the Competition Act, or exempted in terms of that they will not be penalized as anti-competitive if they fall under certain categories. For example, if they are protecting rights under your IPR laws, your patent, copyright, trademarks, or are protecting geographical indication of goods, or the Designs Act, or the Semiconductors Act, basically your IP protection. If your agreements, whether at horizontal or the vertical level, protect intellectual property, then those agreements are reasonable agreements. I mean, those restrictions are reasonable, basically. So then you're not in contravention of Section 3 of the Competition Act or the anti-competitive agreements. So basically, these are two very important sections. Now, this is actually the antitrust part of the Competition Act. Now, coming to combinations. Now, combinations are basically your mergers, acquisitions, demergers. These are regulated by the Competition Commission. So if you decide to enter into a merger or a demerger, or there's a acquisition, and you meet certain threshold, then you will be required to notify to the Competition Commission to seek the approval whether you can indulge in or whether you can acquire or have a merger like situation. So basically, the thresholds in when it comes to the scope of Competition Commission needs to be looked into. So basically, not all mergers, acquisitions, or not all combinations or demergers, basically together known as combinations. So not all combinations come under the scope of Competition Act or the Competition Commission, but certain combinations. For example, at an enterprise level, if two Indian companies are getting into a combination where the assets are more than 2,000 crore rupees, or where the turnover of such an arrangement would exceed 6,000 crore rupees, then that is when you have to reach out to the Competition Commission, and that's when the CCI will regulate these agreements. Or let's say there's an arrangement between an Indian company and a foreign company, or there's a worldwide arrangement, right? And that arrangement, that combinations assets, the assets of the final combination would be more than 1 billion USDs, where at least 1,000 crores assets would be in India, or where the turnover would exceed 3 billion with at least 3,000 crores in India, then in such case, again, you will fall under the jurisdiction of the CCI for regulation of combinations. However, at a group level, if the arrangement is between two or more Indian companies, if it's between the Indian companies and the assets are more than 8,000 crore rupees, or the turnover of the final product would be more than 24,000 crore rupees, that's when again you have to notify to the CCI. And at a group level, if we talk about at a worldwide level where there's an arrangement with an Indian component or an Indian party, if the assets of that final product would be more than 4 billion US dollars, where at least 1,000 crores would be in India, or where the turnover is more than 12 billion US dollars, where at least 3,000 crores turnover would be in India, then in that case, this is the threshold you meet that you would fall under the jurisdiction of the Competition Commission, and you will have to notify the Commission that you intend to get into this combination. So basically, while checking that these combinations will be allowed or not, or whether they're anti-competitive, the Competition Commission will look into whether these are causing an appreciable adverse effect on competition. So they'll look into activities, for example, whether they are the combinations of the same group of companies, or where the so basically these are some of the appreciable adverse effects that needs to be looked into. Whether these, sorry, ignore that. So like I said, when entering into a combination kind of an arrangement, the CCI will look into, once you notify the CCI will look into whether these agreements are causing an appreciable adverse effect on competition. For example, you're getting into an arrangement which will foreclose the market, or which will force the existing competitors to move out of the market. So these are some of the situations which CCI will look into, and if that's the case, the merger may not be approved. You have to look at the trigger event for notifying. However, now because of Green Channel, things have been made easier. But you have to also look into whether these the CCI will also look into whether these combinations are anti-competitive or not. However, not all combinations will be considered anti-competitive. Whether when there are combinations within the same group of companies, where a parent company is, buying out assets of the subsidiary company, then that kind of combination, being of the same group, will not cause an anti-competitive or an adverse effect on competition. Or where the acquisition is not more than 15% of voting rights, or where the player or the acquirer already has 50% of the shareholding, or where combinations are entirely taking place outside India and will have very little effect on markets in India. So these are some of the exceptions, let's say, to the combinations that the CCI will, consider. So talking about Green Channel. So Green Channel were introduced last year in 2019, which made filing for combinations much easier. So basically, earlier we used to file several forms like Form 1, Form 2 before the Competition Commission, asking them to give approval. Now, Green Channel is basically more like an automatic route. Now, when you know that there's going to be a combination which is not going to cause an adverse effect in the market, and which falls under those certain thresholds, and basically they do not have any horizontal overlaps of the parties, or there's no potential vertical relationship, or no complementary business activities. Basically, this combination will not adversely affect the market in any manner, considering all plausible alternative market definitions. That's when you can get an approval from the CCI on automatic route. So you can go through the green channel. It's similar to your green channel at the customs at the airport, where you're not carrying anything which is, which will be considered under the Customs Act, and you walk through that green channel. Similarly, if there is a combination which does not have any horizontal or a vertical overlap, or does not have any complementary business activities between the parties, and it seems that there is not going to be any adverse effect, because there's nothing that overlaps, so you can get an approval automatically under the green channel. So you can file under the green channel and get an approval. So the first case was actually under the green channel was with respect to your SL mutual funds. So the Sachin Bansal group, that entity, decided to enter into a combination, or decided to acquire SL mutual funds. So two very different very different markets, or two very different products or services, let's say, because Sachin Bansal group was really into digital stuff and IT and technology, whereas mutual funds were a completely different market. Okay, so these two markets, these two services did not have any overlap, did not no horizontal or no vertical overlap, no relation to each other. And it was seen that this seems to be a very safe combination, and there's no point of unnecessary doing a lot of filing, which is why this was the first green channel combination which was received by the CCI, and it was approved automatically. However, there are risks to green channel. Like, sometimes people decide to, at the airport, people decides to walk through the green channel, and turns out, they are carrying things which are prohibited under the Customs Act. Similarly, at times they might be filings, or certain parties may decide to, take the green channel route. But in future, if it turns out that this arrangement, which was automatically approved by green channel, this is causing an adverse effect, or is likely to cause an adverse effect, that's when the CCI will take note of it and decide to take strict actions and penalize the parties. So these are basically, this is how combinations take place. So there have been a number of combinations which were approved by the CCI. Like I just told you, under the green channel, this was SL mutual funds. But prior to green channel, PVR and DT cinemas, they had a combination. Sun Pharma and Ranbaxy, there was a merger. Wholesome and Lafarge, that was another merger that was approved by the CCI. So there were some few landmark cases of combinations which came to CCI and got approval. Now let's talk about what CCI's organizational structure is like. Like basically, what does CCI comprise of or consist of? So Competition Commission of India, or the CCI, is the sectoral regulator that regulates all competition law related issues. It consists of a chairperson, and currently there are two more members, so it's three members. But as per the Competition Amendment Bill 2020, it seems that they're going to go back to the older structure where it's going to be chairperson plus six members. But currently there is one chairperson with two other members, and under these chairpersons there are various levels. There are three different levels. There's a secretariat, there's a division, and there's the DG office. So basically, when we go approach the CCI, our hearings take place, or the decisions are made by the chairperson and the members. And once, let's say, the prima facie case is built and it's sent in for investigation, the investigation is taken place by the DG office, or Directorate General. And like I told you, there are various divisions under the Competition Commission or under the chairperson and the members. These divisions look into various aspects of competition. So there's an antitrust division, there is an advocacy division, there's an economic division, there's a combination division. So those divisions, they work in back end to ensure that Competition Commission is able to work perfectly. Competition Commission is actually a quasi-judicial body which has to follow the principles of natural justice, but does have some powers of the civil court. Basically, they can summon or enforce attendance or examination on oath. They can discover or ask for production of documents. They receive evidences on affidavit. They can examine witnesses and documents, and they can requisition. They can ask for requisition or of public records under the Indian Evidence Act. So they do have some powers of the civil court. However, they're a quasi-judicial body. There is no judicial member who's part of the CCI. CCI is currently, or basically is, managed, or basically the members and the chairperson are bureaucrats. They're not judicial members. In the law, there is, that is one issue which is been talked about since some time, that there is a need that there should have been a judicial member in the CCI, but that's not the case. Now, all appeals from CCI earlier used to go to COMPAT, but now they go to NCLAT. And from NCLAT, the appeal goes to the Supreme Court. Now, coming back to CCI, now basically, how do we file a case at the CCI? Now, the CCI will basically, for a case initiation, either the information needs to be received. So information can be filed by an individual, enterprise, could be anybody, or where a reference has been received from a government body, or sometimes CCI even takes up cases suo moto. When these cases, or the case initiation takes place, or these cases, or the information has been filed before the CCI, or it reaches the CCI holds an ordinary meeting of the commission to determine whether a prima facie view needs to be taken or not. Basically, they decide at a prima facie level whether this case seems to be violating the provisions of the Competition Act. Now, if at that ordinary meeting, basically that hearing is called meeting, so the parties are going to be present, and there's going to be a basic prima facie view will be taken. If the CCI decides that yes, a prima facie case is made under section 26(1), then they send that case to the DG, the Director General, for investigation. If no, then that case is closed, and you can go for an appeal against that closed case. But if a prima facie case is made, that is not an appealable order. So the other party against whom that prima facie case is made cannot appeal that order. So once it goes to the DG for investigation, the DG will prepare a report within a certain time, which is given to them. Normally it's 60 days, 180 days, which is extendable. And after that report is finalized by the DG, after investigation, dawn raids, summoning of people, production of documents, all the powers, under the Indian Evidence Act to call for evidences. After that report is made, it goes to the CCI. Now, once it comes back to the CCI with the report, that case, the DG has prepared a proper report, then CCI forms an opinion whether a contravention was found, will look into whether the contravention was found by the DG or no contravention was found by the DG. Whatever the case may be, the DG report is given to parties for objection. Whether a contravention is made or not, the parties then put forward their submissions with respect to their objections, whether they agree or disagree with the DG. On the basis of those objections, the CCI holds the final hearing where CCI considers the DG report and the objections which are received by the parties. On the basis of that, the CCI passes its order and decides the case. So that's how the functioning of CCI takes place, and CCI decides matters. Like I told you, in case you're not happy with the orders of the CCI, then the appeal lies with NCLAT, and from NCLAT it goes to the Supreme Court. Now, CCI has powers to penalize the parties. Now, that penalty can include basically those penal provisions, or basically the things which can come in the order could be a cease and desist order. So CCI can ask the entity or a person or an enterprise to cease or desist from doing certain activity which is anti-competitive, or is abusing, or cease or desist from entering into that combination. CCI could also penalize the party for that penalty will be up to 10% of the average turnover for the last 3 financial years. So basically, it's because the term says average turnover, it doesn't specify whether it's average product turnover, average relevant market turnover, or average global worldwide turnover. So it's very silent on that, and in number of cases this has been discussed, and there have been times when the appellate tribunal has decided that this turnover will be relevant turnover and not the worldwide global turnover, or the turnover of that particular business, or that particular income or profit that was made at that particular period. But let's say this we consider as it is, then in most of the cases CCI penalizes the parties up to 10% of the average worldwide turnover, until unless they decide to consider the relevant market or relevant turnover. So that's how they decided. Now, in case of cartels, the penalty is up to 10% of the turnover, or 3 times of the profit for each year in continuance of that agreement, whichever is higher. So let's say the cartel kind of an arrangement went on for 10 years. So CCI can penalize the party up to 10% of the profit that was made for last 10 years, or 10% of the total turnover of that particular cartel, whichever is higher. The CCI can look into that. They could ask that these anti-competitive agreements be modified, and it can even ask, in case of dominant position cases, it can ask the division or the enterprise to abstain from doing certain things. When in cases of cartels, or section 3, it's seen that certain officer of an enterprise was also found in contravention, then they'll not only penalize the enterprise, but also the particular that person or the officer who was the signing authority, or who was holding or managing that particular transaction. And in cases of combination, the CCI could approve the combination, or approve it with certain modifications, or just refuse the approval. So these are certain powers of the CCI, or you can say these are certain orders that are passed by the CCI when passing the final order. So this is how the CCI functions, and this is what the Competition Act is all about. Now, coming to the Appellate Tribunal, what NCLAT is. So, like you're all aware, National Company Law Appellate Tribunal is the body which now is headed by a retired Supreme Court judge and two members. So, NCLAT is the appellate authority, and an appeal from the CCI when filed to NCLAT needs to be filed within 60 days of the order. Now, a lot of landmark orders are, appealable, were appealed and decided before the NCLAT, and those orders basically, which are specifically provided under 53A, subsection A of the Competition Act. Basically, like I gave you an example where a prima facie case is not made. So then you can appeal the order. Or where a final decision, you're not happy with the final decision of the CCI, then you can appeal the order. But if the CCI decides to allow form a prima facie opinion and ask the DG to investigate, then this is one of a scenario where the party cannot approach the appellate tribunal and file an appeal. And the appellate tribunal is basically, the NCLAT is one of the bodies which will award compensation in cases of anti-competitive agreements or predatory pricing cases, basically, where it is seen that the party which was which suffered because of that predatory pricing or because of that conduct needs to be compensated. So this award for compensation will be decided by the NCLAT or the appellate tribunal. So this is what most of your antitrust in combination under the Competition Act looks like. Like I told you earlier, CCI also has powers to talk about or work towards the advocacy. So competition advocacy is one of the very important tenets or one of the very important tasks of the Competition Commission, because competition law is a very new law. It only came down in 2002 and came into effect in 2008. The body was formed in 2009, and so it's at a very nascent stage. So Competition Commission has to play a very active role in propagating competition advocacy. So they take suitable measures for promotion of competition advocacy, in creating awareness, in imparting training, and talking about it. So there are a lot of radio ads that you hear day in day out about the Competition Commission, and basically this is how the Competition Commission tries to make make the public aware of competition law in the market, or that there is a law that protects players, smaller players in the market, or protects consumer in the market. And that's how they, because of competition advocacy, they try to form that kind of, they kind of strengthen that kind of awareness. So basically that's today's seminar, that's today's competition about, and hope you liked it. Thank you. Let me look at some questions that you have here. No, I don't think. Okay, like somebody has mentioned something about MRTP. So MRTP was an erstwhile body to the Competition Commission. However, the scope of MRTP was very limited. Like I told you, in 2002, when the act came into place, there was a need for a wider act that not only looks into the damages or the contravention that the consumer faces, but also looks into anti-competitive agreements and abuse of dominant position, and also talks about, or decides or regulates combinations, your mergers, acquisitions, demergers. So that's why there was a need for the Competition Commission, or the new Competition Act 2002. And I think that is all for now. If somebody has some questions, I'll be happy to answer. Okay, great. Seems nobody has any questions. So that will be all for today, and I'm signing off. Thank you so much. Bye bye.